Well, good morning, everyone. Welcome to our webinar. I think it's about 7:30. I know we'll have a few more people trickling in, but we'll go ahead and get started. My name is Denise Kranich, and I'm the Senior Director of Development for the Foundation, for the MSV Foundation. Welcome to this morning's webinar about telemedicine and the practical considerations from a licensure, reimbursement, and liability perspective. We are pleased to welcome back Scott Johnson from Hancock Daniel Johnson, a 2021 annual meeting sponsor. Thank you so much for being a sponsor. We really appreciate that. Scott, of course, is a seasoned expert in governmental affairs and has lobbied for clients on the front line of healthcare legislation for over 25 years. His steadfast presence in the Virginia General Assembly has earned the recognition and respect of an ever-changing roster of influential legislators and statewide office holders who seek his counsel when governing the most complex healthcare issues facing clients today. As in customary with all of our MSV webinars, I'd like to cover a few points. Following the presentation today, we will have a short Q&A portion. I would like to remind everyone to please utilize the Q&A function at the bottom of the screen to ask your questions. If a question is not addressed, please email the MSV team at memberservice@msv.org. Okay, now with all of our introductions out of the way, I'd like to hand it over to one of our favorite speakers here, Scott Johnson. Thanks, Scott.
Thank you, Denise. Good morning, everybody. Hope you're doing well. Happy April the 19th. Do want to talk about telemedicine this morning. Certainly this topic we could talk about all day, and you don't want me to do that. But instead, we wanted to hit some key highlights for you. None of this is going to replace you reaching out to your counsel to talk about your specific situation you may be looking at or to making sure you're complying. But as we go through this, certainly welcome any questions you have. Okay, let's advance the slide, Taylor. So I describe telemedicine and have for a long time as sort of the three-legged stool, meaning there are three things you have to consider anytime you're looking at engaging in telemedicine or bringing in telemedicine services. The first one is licensure, making sure you're squared away, or whoever you're bringing in to Virginia or where you're delivering services is squared away with licensure of their respective board of medicine. The second issue is reimbursement. There are rules that may change reimbursement to say when you can get paid, when you cannot get paid, is it a reduction in payment, and who is paying is also going to be a question we're going to look at today. Liability, always a big issue. You can't have a webinar this time of morning and not talk about getting sued, but it's very important that you take the necessary steps to check that off. Next, I want to just give you a highlight of 4 telemedicine bills that were enacted by the 2022 Virginia General Assembly. This is not an exclusive list, just some key bills that I think you may want to consider as you navigate these waters. And then we're going to wrap up with any questions that you may have. Okay, let's move to the next slide. First leg of our stool. And I want you to think about this. Many of you on this call may be saying, well, I'm interested in listening because I may want to provide telemedicine services in another state or the District of Columbia. But some of you on this call may be thinking, my practice can be enhanced if telemedicine services are brought in by a provider in another state. So I want you to think about it both ways as you look at it. Generally, the rule of thumb when it comes to licensure is where the patient is located is going to dictate what the rules are. So if the patient is in Virginia, Virginia law is going to dictate generally what license you do or do not need. Same thing would be true in District of Columbia, Maryland, or California. And so that's how you need to approach it. The first series of questions you would ask yourself is, do I already hold an active license in the state where I'm providing telemedicine, or does the physician or nurse practitioner or PA who's looking to provide telemedicine services in Virginia already hold a Virginia license? 9 times out of 10, if you already do, or you apply for one and get it, you can. Just a quick caveat. Virginia is very fortunate. Our Board of Medicine licenses practitioners for a 2-year license. They generally review on your anniversary month. Virginia license by the Board of Medicine for physicians is roughly $337 for each 2-year period. That is very cheap compared to our sister jurisdictions that are well into the $700-800 amounts. So sometimes it actually can be cost effective to apply for a full license. The second question is, if you don't have an active license, what means might you pursue to obtain one? And Virginia, for the last 5+ years or so, has had a process called licensure by endorsement. This would be a doctor in New Jersey, a doctor in California who's practiced for 5 years, has not been in disciplinary trouble or medical malpractice trouble, basically has a clean record. They are able to apply in Virginia for a licensure by endorsement. And that basically is a streamlined process where they do not have to provide as much background information to be primary source verified. They basically have to say, here's where I went to medical school, here's where I did my residency, if I'm board certified, here's my National Practitioner Data Bank report. So that is another vehicle that is quicker 9 times out of 10 than applying for a full active license that needs all the primary source verification by our Board of Medicine. The third question you may want to ask yourself, and if you have peers in other states, you may have heard of the Physician Medical Compact licensure process. There are a handful of states somewhere in the 15 to 25 range that have elected to join a compact, meaning an arrangement between multiple states. And there are different types of licensure compacts depending on who the licensee is. For example, nursing RNs have a licensure compact that works extremely well in multiple states, huge success. So you can be a Florida nurse licensed under the compact. And if you are, then you can come here and provide nursing services in Virginia or through telemedicine, whatever it may be, without having to get a Virginia license because Virginia has joined the nursing compact. But for physicians, Virginia has not joined the compact. Several reasons for that. Primarily, the speed to get a license in Virginia is quicker through the endorsement process than under the compact. Under the compact, you have to pay to have that license in addition to Virginia, and those fees can run into the 4 digits. And next is a concern about how the compact, the folks that oversee it, handle discipline. So a Virginia licensed doc could have a complaint filed against them by a patient saying, I don't like your hair color. That complaint could be closed, but yet if it's got to be reported to the compact, that could be relitigated, and that is of concern. But if you've got a situation where you as a Virginia physician are licensed in West Virginia, which is a compact state, and you want to rely on that license to provide care, that may be an option for you as well. The other thing you would want to ask yourself is, are you in a time or a situation where you can practice through telemedicine without having to have an additional licensure? And we think about the executive orders and the statutes that were triggered during the period of COVID and the coronavirus times. And we have processes available where a license may not be required, but often a notice or some type of registration with the state licensing entity is going to be required. So as you navigate the first leg of the stool, that's licensure. And those are the questions you would need to be asking yourself as you go through that. So let's move to the next slide and talk about the second leg of the stool, and that is reimbursement. And this probably gets the most attention as the most popular leg of the stool because nobody wants to work and not get paid. But at the same time, this leg of the stool seems to overshadow licensure and liability. And so when people think about telemedicine, they think, well, CMS has sent out something for Medicare that says XYZ when it comes to telemedicine services. Well, that's a true statement, and that's an important statement, and you rely on that statement, but don't have blinders on. Think about the other legs of the stool that you need to look at. So as we work through the various types of payers, be mindful that the rules are not all the same. And just because you see that CMS has sent something out regarding Medicare, don't assume that Anthem commercial coverage or Aetna commercial coverage or United commercial coverage or Virginia Medicaid is going to follow verbatim those. You need to make sure that you are prepared, patient specific, insurer specific. So the first thing we want to talk about with Medicare is obviously during COVID, we have been and are continuing to operate under public health emergency orders that in some instances on the Medicare level have been extended until the summer months. Another 90-day extension was issued last week. And that gives special permission to obtain reimbursement without having to abide by every routine, standard, ordinary rule of telemedicine. In some instances, the basic underlying requirements have not been altered by that, but where they could grant relief, they did. You also probably have heard that some states have obtained from CMS, Center for Medicare Services, waivers, meaning that a state is asked permission from the feds to waive certain requirements for the period of time. So you need to be thinking of those issues and make sure you clearly understand those guardrails on your Medicare population. On your Medicaid population, the state level, have to give a big shout out to DMAS, our Department of Medical Assistance Services that oversees Medicaid. They are extremely vigilant about providing participating provider memos to tell you the rules of the road in navigating all issues during COVID and especially on telemedicine. So as they get a waiver from CMS or a public health emergency order comes down that they intend to follow, they will issue a provider memo. These are posted on their website on a dedicated web page to basically say, during this period of COVID, here are the rules of the road. And these rules of the road will stop on X date. And it's oftentimes they will issue a subsequent memo that says, for telemedicine, these rules of the road are being extended, they're being stopped, they're being altered, and here's what you need to do. Here are new codes you need to use when you're billing for telemedicine. These codes are in effect through X date. So make sure your practice manager, your billing folks are watching those very closely. Next issue that has impacted us on telemedicine are the governor's executive orders, or if the commissioner of health issues a public health emergency order. In our state statutes, the governor and our government have many powers that can be triggered by an executive order declaring an emergency. And during COVID, we had multiple ones that spanned probably over 40 different executive orders on different approaches. And some of those orders enable the statutes to be brought to life to say, if there is a disaster, here's what you can do and have flexibility there. A lot of those orders had specific end dates. And so again, watching the orders, making sure if you think I'm engaging in telemedicine, I'm billing and reimbursing this way for this period of time, don't assume that's forever. Make sure you've got some routine checks. Make sure if you're relying on an order and it says it ends April the 1st, that you go back and calendar something to make sure somebody on your staff looks at it. And the last one is on the commercial health insurance market. And I'm talking here about not only the commercial group market, but a large part of the self-insured. Again, the health plans were very good during COVID in sending out notice to participating providers to say, here are the rules we are voluntarily relaxing. Here's what we're going to pay for. Here are the rules of the road. Good for them to communicate to you, challenging for you, because again, many different providers, many different payers. And so trying to navigate what you can do and get reimbursed for and what you can't are issues to consider there. Okay, let's look at the third leg of the stool, and that is a liability. Nobody wants to talk about this, but again, equally as important. The first thing with your professional liability insurance policy, most of those policies have some language in it along the lines of you are covered for any medical incident arising out of your care of a patient. And that's a very broad coverage category, which favors you and benefits you. But the first thing on the liability front, if you're a Virginia doctor and looking to provide telemedicine in another state, or you're a West Virginia doctor looking to provide telemedicine services in Virginia or making arrangements to do so, always consider, what does your policy say? And the way to do that is consult with your insurance agent, or like in the case of the medical society's insurance agency, to say, what am I covered for? If I'm a Virginia doctor and I start providing care to West Virginia patients, am I covered, or is that excluded? Or do I have to give notice to my carrier? Do I need to buy any type of additional coverage to make sure that I am protected and are insured? The next thing to consider is in Virginia, we're blessed to have a medical malpractice cap, meaning a limitation on damages for any medical malpractice actions that arise in your care of Virginia patients. But if I'm a Virginia physician and I choose to provide care in West Virginia or another state, many of them do not have a cap like Virginia. To my knowledge, there's only the 2 states that have a total cap like Virginia. Other states just cap portion of things, like they may cap pain and suffering. They may cap economic damages, but just because you've got a total cap in Virginia, if you're a Virginia doctor providing care in New Jersey to a patient in New Jersey, that Virginia medical malpractice cap is generally inapplicable. And if New Jersey does not have a cap, then you are going to face the full exposure of recovery that may come back from a jury or a judge. So be mindful of that liability risk as you do that, because there is a increased risk in providing care. Be also mindful of this. If you're a doctor located in Grundy, Virginia, and you're providing care to a patient in Knoxville, you may think, well, if I do anything accidental, because I wouldn't intentionally do anything wrong, but if I have a situation that may arise in a medical malpractice cap, certainly I would get sued in Grundy, because Grundy is my hometown. I know everybody in Grundy. I've cared for everybody in Grundy. But that's not the case. Generally speaking, where that patient is located, you have availed yourself to the jurisdiction of that state. So likely you would be sued in Tennessee and not in Virginia. So another issue to think of as you navigate through this process. Now let's take a turn away from the 3-legged stool. That's your analysis and you're thinking through that. And let me highlight for you 4 bills from the Virginia General Assembly, the 2022 session. And these bills are the first 2, Senate Bill 319 and 1187. They are identical. This bill, or these 2 bills, address a particular issue. You heard me mention that during the COVID declaration, when Governor Northam issued Executive Order 51 declaring COVID as a disaster or an emergency, that automatically triggered certain statutes that we have on the books that gave particular powers to hospitals, nursing homes, and dialysis centers. Basically, those powers enable them to bring in providers from other states who are licensed in other states, but not Virginia, to have them work for the period of time of the disaster, and required certain notice to be given to the Board of Medicine and Board of Nursing or whoever would be licensing them here. But short of an emergency order declaration, those same individuals did not have the ability to bring in additional staff. And there is an understatement to say that healthcare providers are burned out and exhausted, and we need additional resources for COVID. So these 2 pieces of identical legislation were passed to basically say, even when there is not a disaster declared, in certain circumstances, certain people can bring out-of-state providers into Virginia to work for a period of time. And so let's walk through what is permitted under this bill. This piece of legislation will enable 3 entities, a hospital, a nursing home, or a dialysis facility, to be able to bring into Virginia, to have work in Virginia, out-of-state providers who are licensed, registered, or certified in another state for a 90-day period if they meet certain conditions. So this is a situation that a hospital in Enrico can bring in a nurse from California, a doctor from Texas, a respiratory therapist from Atlanta, and have them practice here in Virginia for an initial 90-day period, meaning they can do it today, excuse me, even if there's not a declaration or disaster. There are certain things that have to be done by that hospital, nursing home, or dialysis center in order to bring these folks in. They've got to verify that that out-of-state provider's got a valid license or is registered. They have got to pull down a national practitioner data bank report on those individuals. They've got to notify whatever board would regulate them here that that individual they're bringing in has been offered employment, and that they are intended to be brought into Virginia for that. And once that individual is here, if during that 90-day period, that individual says, you know, I think having a license in Virginia would be good, and they apply for a Virginia license with one of the board that regulates them, they may be granted permission to practice an additional 60 days. Now, let me give you an example of what that would look like. So a nursing home in Fairfax wants to bring in a gerontologist from the state of Maryland, and that Maryland provider does not have a Virginia license. That individual nursing home would be able to bring in, and we'll call him Dr. Jones. He'll bring in Dr. Jones. He'll have to verify Dr. Jones's license in Maryland. They would be offering Dr. Jones or contracting with Dr. Jones for employment or a contract service. They would have to pull Dr. Jones' National Practitioner Data Bank, and then they would notify the Virginia Board of Medicine that they brought in Dr. Jones. Dr. Jones can work for 90 days. If during that time, Dr. Jones says, hey, Virginia's great, I think I want to pay that $337 and get a license here, Dr. Jones may be able to practice an additional 60 days. Now, Dr. Jones, here's the patient safety piece. When Dr. Jones agrees to come here under this piece of legislation, Dr. Jones is submitting to the jurisdiction of the Board of Medicine. So if Dr. Jones commits a violation, a disciplinary violation, say, for example, Dr. Jones does not prescribe opioids consistent with our regulations, Dr. Jones is subject to the jurisdiction of the Board of Medicine. He or she can be disciplined, fined, can lose their license, can have their ability to practice pulled. Now, the second piece of this legislation is a directive to our Virginia Board of Medicine to pursue reciprocity agreements with our sister jurisdictions. You heard me talk earlier about the Physician Medical Licensure Compact. You heard me talk about licensure by endorsement. Reciprocity is different. We have had in Virginia law for a good while the ability to basically have a one-off agreement between District of Columbia and Virginia, Maryland and Virginia, DC and Maryland, Tennessee, North Carolina, whoever it may be. Our Board of Medicine is actively pursuing reciprocity agreements with DC and Maryland. And basically, this is what I describe is a streamlined, much better physician medical compact. This is a situation where our boards and their boards are working on a unified medical license application that is streamlined, working on a memorandum of understanding. And once all of that is in place, which could be as soon as this summer, you could have a Johns Hopkins physician be able to provide care here in Virginia. If they're licensed under this reciprocity agreement, they would be subject to Virginia jurisdiction and they would not have to obtain a separate Virginia license. The third portion of this legislation that I want to share with you is the fact that this had what we call an emergency clause, which means generally when the governor signs legislation from the previous session, it becomes effective July the 1st. This legislation having an emergency clause required a higher number of votes in the House and Senate, and it got those votes. And so when Governor Youngkin signed it, this became law April 11th, 2020. So it is the law today. It is able to be used today. You may ask yourself, when I was explaining what healthcare providers get to bring in individuals under the statute, and I said it's limited to hospitals, nursing homes, and dialysis centers, that was what is in the statute that enables those same entities during a disaster to bring people in. Interestingly, one of the executive orders during COVID authorized home health providers to be able to avail themselves of bringing in out-of-state individuals. And there were some instances reported to the Board of Medicine that process was abused, and that is being reviewed. And so it's a check and balance. So you ask yourself, could a physician practice avail themselves to this statute? The answer is no. You would have to avail yourself to either licensure by endorsement or one of the other licensure processes. So just two bills to consider there. All right, let's move to two more pieces of legislation for your consideration. Senator Richard Stewart had introduced Senate Bill 369, and Delegate Head had introduced 264. Senator Stewart's from up in the Stafford area, and Delegate Head is down in the Roanoke area. And Senator Stewart had a constituent that lives in Virginia that had gone up to Hopkins for surgical treatment. And during COVID, that individual patient was not able to go back up to Hopkins and be seen by the surgeons up there. And at the same time, the surgeon says, we don't have a pathway at this point to provide care to you through telemedicine because we are not licensed and there's no avenue in any of the executive orders to allow us to do that. So Senator Stewart wanted to get some relief for this, as did Delegate Head. And so basically what this legislation will do, it will allow anybody that is licensed by or regulated by our Virginia Board of Medicine. So it would mean a physician, a DO, a nurse practitioner, or a PA. If they're regulated by our Virginia Board and they're licensed in another state or even the District of Columbia and in good standing, they can practice their profession regarding one of their patients who's located in Virginia if certain conditions are met. Number one, that the practice is intended to provide a continuity of care through telemedicine for that patient. That patient is a current patient of the practitioner, and that patient-physician relationship has been established in the previous 12 months, and that practitioner has performed an in-person exam within the prior 12 months. That they may do that. Our friends at Kaiser sought language in this legislation that was included that basically says, since Kaiser is a closed system, meaning your all of the healthcare is provided by the Kaiser employees or folks they contract with, that as long as you're a patient of one of the Kaiser docs or nurse practitioners or PA, you would be able to use this statute. And all of the Kaiser physicians are already licensed in Virginia, so that's going to make sure that we've got the patient safety piece covered. But one thing interesting, where the last two bills I talked with you about had an emergency clause that was voted on and it became law when the governor signed it, when 369 and this other bill came through, they did not have an emergency clause. So on Monday, April 11th, Governor Youngkin proposed that an emergency clause be added to this bill, and that will be voted on at the reconvened session by the General Assembly next week on the 27th. And if it passes, this statute will become law that people will be able to avail themselves to immediately upon passage. So again, Virginia is trying to be on the cutting edge of telemedicine. The Medical Society has worked every session that I can recall on trying to advance telemedicine. Our safeguards have always generally been, you need to make sure our Board of Medicine has got jurisdiction over the person, and that's usually through licensure of some type. Because that's the only way to protect the public. And if they don't have that, then the public is harmed. But other than that, we have worked extensively through that, and certainly through telemedicine. We seek a lot of advice and sage counsel from Dr. Karen Ruban up at the UVA Telehealth Center and her team, and they have always been kind with their time, and their sage advice is what we have looked to. So Taylor, I want to let's slide to the conclusion question slide, and I think there's a question in the chat, and I'm going to go here and try to click on chat to see if I can see it. Okay, Dr. Reha, good morning, sir. Good to have you. So Dr. Reha's question is, how do you conclusively prove the location of the patient? The patient may tell you they're in Virginia when they're not actually in our Commonwealth and subsequently pursue litigation in another state. Certainly a problem from that perspective, and something that you want to verify on that. A couple of things that may help you on that: asking the patient to verify their address, and asking the patient to and make sure that address is matching what you've got on your records. Secondly, one of the things that you would probably do with this patient is if you have a situation where they are Medicare, Medicaid, or commercially insured, and you've got a access to a point of service, if you will, where you can go in and verify that Medicare is showing that this is an HMO patient through Medicare enrollee, and they're showing an address of Rockville, Maryland, but the patient is telling you their address is another state. You can elect to have the patient pull out their driver's license, assuming they have one, and hold it up to the camera to let you see if the driver's license matches that information. So again, it's the old Ronald Reagan principle of trust but verify. But could you be hoodwinked? Sure. If they do that to you and misrepresent something, then your attorney is probably going to say, if they sue you for malpractice, there may be consideration of whether a fraud claim will be brought back against that patient. But good question, and something good to verify. Welcome any other questions. I see one in the Q&A. Let me see if I can open that. Okay, Dr. Ria. All right, that's the same question we just did. So if any of you have any other questions, please don't hesitate to post them in the Q&A or in the chat, and we'll do our best to grab them. But I would just encourage you that before you launch out on telemedicine or before you decide to expand in your practice, make sure you pick up the phone and check with your professional liability insurance company, check with your counsel, make sure you're covered here, doing it right. And hopefully telemedicine will continue to let you benefit your patients and make a better lifestyle for you where you can, because I know that's what your goals are from that perspective. Not seeing any additional questions at this point. Taylor, do you see any, or Denise, am I missing any?
I don't see any either. We just wait just a couple more seconds here. Hey, you've got Scott Johnson here right now answering your questions. So if you have anything, please, put it in the Q&A. I think I see something that may have come up now, Scott.
Sure. First one, Dr. Coughlin, good morning. Question is, if the patient can't use video due to internet unavailability, certainly a problem and not a rarity. And you're right. There have been situations where, and I have to say that I think Medicaid and the commercial carriers are getting up to speed. You've got some patients that can't use video because they're not familiar with the technology. You've got some patients that you try to use video with and something falls apart and the lines disconnect. And then you've got some patients that are in areas that you don't have internet availability and you've got to resort to telephone audio only. I think the thing that is oftentimes overlooked, and again, I hate to ask you to have to do one more thing, but you need to make sure you document what you went through in that situation. So if Ms. Smith is unable to use technology, it needs to be documented in her EHR or medical record. If you lose connection and you have to go to something, it doesn't have to be long, doesn't have to be elaborate, but you want a paper trail as to why you did what you did on those situations. I think also too, it certainly is a situation that if a payer thinks you made an audio only call and there's nothing surrounding that to say anything more, they may very well say, well, we're going to deny coverage because during this particular time in COVID, there was no waiver, no emergency order, no change in rule that we had. And the time for you and your billing folks to try to appeal that or go through it can be cumbersome. But if you at least have something in your record to say why you did what you did, that hopefully. Dr. Rubin, good morning. Yes, Taylor will make arrangements to share these slides and we'll get these posted. And then Dr. Coughlin, you had a question about, can I charge for this? I assume what you're asking for is, can you charge for the services you're providing to the patient through telemedicine if it is audio only? And again, if there are not pathways with that particular payer, the general rule is audio only is not something that is advocated for or reimbursed for. So you need to make sure that you're trying to have interactive two-way communication, audio-visual communication. Again, if there are any specific circumstances, you need to document those. Otherwise, you probably are going to have a claim denied. And let me go back to the chat. Okay, we covered those. Any other questions?
We're going to wrap it up. So ask your questions. Just a few more minutes here. Okay. Well, Scott, I'm thinking that maybe we are finished for now.
Yes. Thank you so much, everybody, for attending. Have a great day. Anything I can do to help you, don't hesitate to call.
Thank you so much, Scott. We really, really do appreciate you being on the call this morning. You've given us some great information and certainly some things to think about. We really, really do appreciate it. Thanks to all of you again for joining us too this morning. And we will get the slides to you. And if you have any other questions, feel free to ask us and we can get in touch with Scott too. So thank you again so much for joining us. Have a great day. Stay warm. It's chilly out there today. So thanks again. Bye-bye.